Okay, hello. Good afternoon. Thank you for joining us today. We will be doing a presentation on the implied warranty of habitability. Um, if you have any questions, feel free to type those in the chat box, and I'll do my best to answer those at the end of the presentation. So let's start with talking about what is the implied warranty of habitability. Um, It's an implied warranty in your lease that requires your landlord to keep your residence in a tenantable condition. So what does that mean? An implied warranty, it means that it's in your lease by law. So even if it's not mentioned in the lease expressly, it's implied into every single residential lease in California. And what is a tenantable condition? Basically means the rental unit needs to be fit for human occupancy, and we'll talk a little bit more about the specifics of that. Um, the implied warranty of habitability is not waivable. So if your landlord tries to put in your lease that the tenant waives the implied warranty of habitability, that's not enforceable, and your landlord is still obligated to abide by this. Where does it come from? It comes from California Civil Code section 1941. So what makes a unit untenantable? In the California Civil Code section 1941.1 states that a unit shall be deemed untenantable if it substantially lacks any of the following. So, um, effective waterproofing. So if there's leaks coming in, particularly from the outside, like the exterior walls, roof, doors, things like that. Excuse me. Plumbing or gas facilities need to be maintained in good working order. Hot and cold running water with appropriate fixtures throughout, connected to a sewage disposal system, whether that's like the sewer system or um, like a um, septic system outside of the home, but there needs to be some type of sewage disposal system. Heating facilities need to be maintained in good working order. Under California law, air conditioning is not covered. That's something that these days is kind of becoming an issue. But we'll talk more about that in a few minutes. Um, Electrical lighting needs to be maintained in good working order. There needs to be an adequate number of trash receptacles on the property that are kept in clean and good condition. Um, the building grounds, they need to be clean and sanitary, free from the accumulation of garbage and rubbish, rodents, vermin like bugs at the start of the lease. And all the areas that are like common areas, they need to stay that way the entire for the duration of the lease. It's the landlord's responsibility. So if there's a courtyard or like the parking area, it's the landlord's responsibility to keep that stuff clean. Of course, you're inside your unit, it's your responsibility to keep it clean once you're living in there. Floors, stairways, railings need to be maintained in good repair. For residential hotels, the landlord must provide a locking separate mailbox for each tenant. Section 1941.1 also includes residential units described in Health and Safety Code sections 17920.3 and 17920.10. So what does that mean? Basically, those sections of the Health and Safety Code just include more conditions that are required, that the landlord is required to meet, and we'll talk about those too. So Health and Safety Code Section 17920.3. If any of these conditions exist, then the landlord um, needs to repair these as well. So lack of or improper bathroom, bathtub, or shower, kitchen sink, ventilation equipment, minimum amounts of natural light or lack of natural light in the home. So if there's no windows, that doesn't work. Um, Room and space dimensions that are less than required by the code. So that's something you would kind of cross-reference with the local code where you live. Dampness of habitable rooms. Uh, okay, and any of the following conditions exist. So the infestation of insects, vermins, or rodents, as determined by a health officer or code enforcement. That's really a big one. A lot of times landlords try to put pest control off on the tenants. It's not the tenant's responsibility. So, if you're having a pest issue, you know, it's generally the landlord's responsibility to address that. And there may be limited times when that's not the case. We'll talk about that later, but very limited. Visible mold growth is another one. Landlords always try to put that off on the tenant, but that is the landlord's responsibility. General dilapidation or improper maintenance. So this is where the air conditioning comes in. If you have an air conditioner, and it's not working, I on behalf of my clients usually argue that that's a general dilapidation or improper maintenance. So even though the code doesn't require air conditioning, if you have one that's not working, I think there's an argument there that that's a violation. Um, Lack of connection to a required sewage disposal system or lack of garbage storage and removal facilities. Um, more items included under 17920.3, like deteriorated or inadequate foundations, defective or deteriorated floor supports, same with walls, ceilings, fireplaces, chimneys, any of those that can't support the load they're supposed to hold if they're leaning or listing, or buckled, that's a problem. And the landlord needs to address that. Obviously, those would be major safety issues. Okay, Health and Safety Code Section 17920.10 talks about lead hazards. So any like deteriorated lead-based paint, lead contaminated dust, soil, or disturbing lead-based paint without containment. So those are all violations. So if you have an older place where there might be lead-based paint and it's peeling off the wall, say, that's a problem. Um, or if they come to remove the paint, maybe they're sanding the wall, and they're not, taking the proper safety precautions to deal with the dust that comes with the sanding. That would also be a problem for the landlord. Okay, so let's talk about when the landlord does not have a duty to repair. Um, so the landlord does not have a duty to repair the dilapidations if the tenant is in violation of any of the following obligations, and I'll tell you what those obligations are on the next slide. And at the same time, the tenant's violation of the obligation substantially contributes to the existence of the dilapidation or interferes with the landlord's ability to repair the dilapidation. So, what are those obligations? One, okay, the tenant must keep the part of the property that they occupy as clean and sanitary as possible. That's where I talk about the pest. So, if you have a pest issue and your place is extremely filthy, maybe full of trash, there's going to be an argument there for the landlord that they're not responsible for addressing the pests. So it's also your duty as a tenant to dispose of all garbage and other waste in a clean, sanitary manner, to properly use and operate all electrical, gas, and plumbing fixtures, keep them as clean and sanitary as possible, not to permit people um, including yourself as the tenant on the property with the tenant's permission. So to destroy, deface, damage, impair, remove any part of the structure. So obviously, if you punch a hole in the front door, or you have a guest over that punches a hole in the front door or breaks a window, um, then it's on you to repair that. That's now the landlord will probably repair it and bill you for it, but technically that is your responsibility since you intentionally did that, or your guest intentionally did it, who you're responsible for your guest. And then to use the portions of the dwelling for their intended purpose. So if you're renting a residential place and you're running a mechanic shop in the garage and that leads to some issue, then that's going to be on you. Or you're running like a commercial kitchen out of your residential apartment and something like that happens, that's probably going to be your responsibility to repair that. So another thing that's required under California law, proper locks. California Civil Code Section 1941.3 requires deadbolts on swinging exterior doors, proper locks on exterior windows, and also proper locks on doors for ingress and egress to community areas. Of course, if the locks are not working properly, it's your responsibility as the tenant to notify the landlord. We'll also talk more about that later on. A telephone jack. So 1941.4 requires that every rental unit have at least one telephone jack. I know that's somewhat of an outdated law at this point, but for now, it's still a requirement. We'll see if that, if they ever lift that requirement. So let's talk about restraining orders. This is not directly related to the warranty of habitability, but it's kind of on topic. So, and it talks about landlord's obligations. So I think it's important to touch on. So if one tenant gets a restraining order or protective order, criminal protective order against another co-tenant, the landlord now has to change the locks upon written request within 24 hours of being provided a copy of the court order, and they need to provide a new key to the tenant, the protected tenant, of course. If the landlord does not change the locks within 24 hours, the protected tenant may change the locks themselves. It must be a lock of same or better quality than the original, and they should notify the landlord of the change within 24 hours and provide the landlord with the new key as soon as possible. The interesting part, I think, about this statute is that once that happens, the landlord is no longer liable for their obligations in the lease to the excluded tenant, meaning the person who the restraining order is against. The landlord locked them out by changing the locks, and they don't owe that person, even though there's a contract. The landlord's kind of out of the contract. They don't owe that person, the right to be able to access the apartment or the rental home anymore. But the really interesting part is that that person who's not allowed to go there anymore is still obligated to the landlord for rent. So, if somebody gets a restraining order against them and the landlord locks them out like he's supposed to, or she's supposed to, and that person, the person who's still living there doesn't pay rent, the landlord can go after the person who has been excluded from the home to force them to pay rent, even though they have no right to be there anymore. Okay, so what can you do about habitability issues? So let's say, any of the issues we've described with the condition of the home, that arises where you're living. What should you do? So, first of all, the landlord is required to address those issues within a reasonable amount of time after they're given notice. Now, notice can be oral or written. Um, but the first thing you have to do as a tenant is give your landlord notice. I always recommend giving notice in writing. That way there's no dispute. Obviously, if you call your landlord on the phone and they say they're going to fix something and they don't, there's a good chance later they're going to say, well, they never told me about it. So if you send them a text or even better, an email, there's no disputing that you reported it to them. So what does a reasonable amount of time mean? Well, it depends. I think, the law says 30 days is presumed to be reasonable, depending on the circumstances. So if you have, a broken light, a light fixture that's not working, like 30 days is probably reasonable for that. But obviously, if your toilet's leaking all over the floor, 30 days is not reasonable. They're gonna need to get there immediately. Um, so it really depends, but generally for most situations, 30 days is considered reasonable. So let's say you report um, one of these issues to your landlord and they fail to repair it. What issues do you have at that point? So one issue, or what options, sorry, do you have at that point? So one option you have is to repair the item and then deduct whatever the cost was from rent for next month. Um, so let's say, the light fixture, like I said, the light fixture goes out. and landlord doesn't come fix it. So you go, you buy a new light fixture, or maybe if it's even just a new light bulb, but that costed say 20 bucks. Next month when you pay rent, you can deduct $20 from your rent, send the landlord the receipt. Technically, that's valid under the law. The other option, or another option you have under Section 1942 is to basically terminate the lease and move out, and no longer be liable for the lease. But there are with both of these options, there are problems. So you kind of open the door to, an argument. Like, let's say you decide to repair and deduct. You have a leaky faucet. Landlord doesn't fix it. You take care of it yourself. So then that was a hundred bucks. So then the first of the next month you pay rent, but you deduct $100 from the rent. You're kind of opening the door to the landlord now saying, well, you didn't pay the full rent. You owe me $100. I'm going to try to evict you, or because you're behind in rent. Even though you have this argument, technically legal right, you're opening the door, and you really never know which way that's going to go. So these aren't the best options. But they are there if you need them. I would always recommend consulting with an attorney before you use either of these options. The other thing with moving out and terminating the lease, it's like, well, let's say if you have 6 months left on your lease, you say, well, landlord's not fixing these problems. I'm going to move out and not pay any more rent. There was 6 months left on your lease, and you're saying, well, I'm terminating the lease under Section 1942, and the landlord's saying, well, that wasn't either he or she didn't report this issue to me, or it wasn't a habitability issue, or I did fix it, and all of a sudden they're trying to sue you for 6 months worth of rent. Now maybe you end up winning that case like way down the road, but winning that case is going to take a lot of time and headaches. So before you exercise either of these options, think about it carefully, talk with an attorney, because there are definitely they're powerful options, yes, but they're also risky options. So you want to take that into consideration. Okay, so Section 1942, as we talked about in the last slide, the first and most important thing is that the landlord has notice of the issue. Of course, we can't expect landlords to repair things they don't know about. So you have to tell them. Again, I recommend you do that in writing. Um, so what other options do you have besides repair and deduct or terminating the lease? Luckily, there are other options. You can call your local code enforcement department or health department, depending on what the issue is. If you're dealing with mold or rodents, generally you're going to call health department. If you're talking about broken windows or other things like that, you're going to want to call code enforcement. But if you call the wrong one and they come out, they'll usually call the other, or you'll get it figured out. They usually come pretty quickly. That's the good news. And if they agree with you, they'll basically issue a citation to your landlord saying, hey, you have 35 days to fix this issue. After 35 days, you're going to start accruing fines, like daily fines for not fixing it. So this is a powerful option that's a lot better than the other two, in my opinion, that I explained on the last slide. You can also sue your landlord in small claims court, something we help people with a lot here at Hera. It's a good option because it's fast, it's cheap. There's no lawyers. Like as attorneys, we can help you prepare in the background, but we can't go to court with you. But that also means your landlord can't show up with an attorney. So that is it's a good option too. And then seeking a private attorney if they'll take the case on a contingency basis. So some of the more severe habitability and things like that, oftentimes, you can get linked up and we can help with that with a private firm that will take your case on a contingency basis, basically meaning no money up front. And if they win, they'll take a percentage of the recovery, and that's a good option too. I think it's becoming more and more common in California for those cases to have large amounts of damages associated with them. So restrictions on the landlord. So let's say you, like we talked about in the last slide, called code enforcement or the health department. They came out, they gave your landlord a citation. They agree with what you're saying. They say to your landlord, you have 35 days to fix this, and you do not, and the landlord does not fix it. Now, this is a really strong protection for the tenants. So, once that 35 days has passed after that citation, at that point, the landlord cannot collect rent, demand rent, increase rent, or issue a 3-day notice to pay rent or quit. So basically, at that point, you're relieved from your obligation to pay the landlord rent, at least in the short term until they address the issue. So that is a powerful one that I advise people to use often when the circumstances dictate. Once the landlord stops getting the money, they usually move pretty quick. Also, so whether you call code enforcement, whether you take your landlord to small claims court, whether we send a letter on your behalf, whatever avenue you choose for enforcing your rights, you're um, protected against landlord retaliation. So, what does that mean? That means once you do any of these things we just described, for at least 180 days, and in a lot of situations more, um, the landlord can't raise your rent. They can't terminate your tenancy. The only they can't decrease your services. So um the only thing they can really do is still seek to evict you for non-payment of rent after that. So just so you know, and that applies to what is here listed on the slide, which is an inspection by an agency, um, filing a court action like small claims court or an order at the end of one of those actions, notifying them of a bed bug infestation, or just making a written or oral complaint about the condition of the apartment. You lock in those protections, and landlords try to retaliate sometimes, but this is a strong protection. Okay, so here I kind of covered this already. Retaliation includes attempting to evict you, increasing the rent, decreasing the services, report you or people associated with you to immigration authorities, or threatening to do any of the above. And those protections cannot be waived in your lease. If your landlord does retaliate against you, they can be held liable for actual damages and punitive damages for each act. And then attorney's fees, which is a big one. That's a way that makes it more enticing for private law firms to take your case when the statute allows for you to go after the landlord for your attorney's fees. Okay, so your landlord can also not harass you. Um, so under Civil Code Section 1940.2, landlord cannot do any of the following with the intent of influencing the tenant to move out. It cannot violate Penal Code Section 484, which is basically can't commit fraud, try to get you to move out. Penal Code Section 518, they can't commit extortion or blackmail to try to get you to move out. They can't use or threaten force, willful threats, or menacing conduct that interferes with the tenant's quiet enjoyment of the premises. That would create an apprehension of harm in a reasonable person. This is the one we see most. The landlord cannot commit a significant and intentional violation of Section 1954, um, which requires the landlord to enter during normal business hours and provide 24-hour written notice, and limits the reasons that the landlord can enter the unit also, even with notice and during business hours. So there's only a couple of reasons they can enter. I've had a couple of cases recently where the landlords were definitely using entries as, way to harass the tenant. So that's a big one that comes up most often. And then they also, again, just like the last statute, they can't threaten to disclose information about the tenant's immigration status or their occupants, other occupants, or people associated with them. So if you prove a violation of 1940.2 in court, you're entitled up to $2,000 for each violation. Um, so these excluded from her landlord harassment is a good faith written or oral warning given to the tenant regarding conduct that violates or may violate the lease rules or regulations or the law. That's not considered harassment, of course. Or an oral or written explanation of the lease rules, regulations, or laws given during normal business hours is also not considered a violation. So, tips for you if you're facing one of these issues, create a paper trail. This is what I was talking about earlier. Always do everything in writing. Um, that way you have a paper trail. Remember that you may end up in court one day. You may end up presenting this to a judge or some other type of, government official. And, you want to keep the communication professional, to make sure that they, don't see you as the bad guy or the bad girl. So that's a really important part of it. Obviously, once you do that, you send those, correspondence in writing, obviously save a copy. And then any condition, that's in your house, that whatever you're complaining about, any habitability issue, take pictures. Make sure you're taking pictures of that so you have evidence. So, that's the end of the presentation. I think, one other thing I'd want to touch on is, what options do you have, as far as like seeking out legal counsel if you find yourself in this situation? You can contact us at HERA. We do provide free limited scope legal services for tenants, in pretty much any tenant situation except for eviction, unlawful detainer. But other than that, if you're facing any issue as a tenant, reach out to us. We can help you free of cost. We have a lot of experience doing that, and we're happy to help. There may be other tenants' rights organizations, depending where you live. And then also legal aid is an option in some situations, particularly if you're facing eviction. Oftentimes, legal aid can provide free representation or some type of limited representation for those situations. So those are really your options. If you find yourself in this situation. So hopefully you don't, but if you do, we're here. Give us a call and we'll be happy to help. I think that's it for today, unless there are any questions in the chat.
All
Susan.
right. So there is a question in chat. It's talking about if you report to code enforcement and they agree with the complaint. So is the landlord prevented from collecting rent after 35 days?
Thank you, Michael. Yes, if the landlord doesn't address whatever items were included in the code enforcement citation. So if code enforcement gives the landlord a citation and they address the issues, then no, I mean, it's basically resolved and you have to keep paying rent. If that citation is outstanding for 35 days, and they still haven't addressed it at that point, yes, you are relieved from the duty to pay rent. I don't know if that answers the question. If not, I'm looking at the chat box now, so feel free to type a follow up if you'd like. Could that be used as a defense? Well, yeah, because the same statute actually says not only are they prohibited from collecting rent, they're actually prohibited from filing an unlawful detainer, after that 35 days until they resolve the issue. So, yes, that would be a defense. Um, I mean, I think the defense, I'm not an expert in unlawful detainer, so if you find yourself in that situation, you'd want to contact attorney that is, or contact your local legal aid. But I believe that the defense would be that, he or she, the landlord, is prevented from even proceeding with the unlawful detainer because of this outstanding uh, um, code enforcement citation. And to be honest, that's when you really cases like that are when you really start getting into like good civil cases to sue the landlord. And you'd really probably want to reach out to a private law firm. I mean, if there is an outstanding code enforcement citation and it hasn't been addressed for over 35 days, and then your landlord tries to evict you, if I were you, I would go straight to like a tenants law firm that would take your case because like that's major retaliation. There's so many issues there that allow for attorney's fees and all types of other angles to get damages that that's probably a very good case. Well, you're welcome. Thanks for joining us today. I don't know if there are any other questions. I guess not. So thank you for joining. Michael, as always, thank you for your help. You guys, and feel free all attendees to reach out to us anytime, and we'll be able to help you out for your cause. So thanks again. It was a pleasure to do this, and hopefully you don't have a need for our services, but if you do, we'll be more than happy to help you. So everybody have a nice day and a nice weekend. Thank you.